seated, please. Call case number 1524-00054, Health and Human Services Commission versus Navarro. For the appellant.
Good morning, Your Honor. Appellant, HHSC, Joseph Keeney.
Splitting your time, Mr. Keeney?
I'll be reserving 5 minutes.
Okay. And splitting or one speaker for appellees?
Good morning, Your Honor. Mike Lostenberg for the plaintiff, just one speaker for the appellate.
Good. Thank you. Mr. Keeney?
Good morning, and may it please the court. The sole issue in this appeal is whether the court lacks subject matter jurisdiction and should dismiss this case under the state's sovereign immunity. There are 3 primary reasons why Chapter 260A of the Health and Safety Code does not waive sovereign immunity. First, there is absolutely no statutory language, no word nor phrase, that clearly and unambiguously expresses legislative intent to authorize suit against the states. Second, whether a state-supported living center falls under the definition of a facility under the statute makes no difference. Even if it did, though it does not, that would not be clear nor unambiguous language. And third, for the court to accept Navarro's radical position in this case, it would have to reject decades of well-settled jurisprudence and create an entirely new basis for waiving sovereign immunity out of whole cloth.
Did Navarro have another remedy here? If we find that there is no waiver of sovereign immunity, is there something else Navarro could have done?
Under the particular fact pattern, as alleged at least, there was no discovery at the trial court, but at least taking the factual allegations as pleaded, Navarro alleged she did not report abuse and neglect to an appropriate law enforcement authority. If she had, she would have had a remedy under the Texas Whistleblower Act in Chapter 555 of the Government Code. The legislature is in the best position, and I'll go ahead and address this point.
Obviously, the troubling thing is if you've told people, if you see anything going on, call this hotline. She calls the hotline. Aha! Mm-hmm. You've lost because you didn't call the state troopers. I mean, at some point, that can't have been what the legislature intended.
Well, as far as reporting to the hotline, as far as reporting to the Department of Family and Protective Services, that I believe would be a report to an appropriate law enforcement authority.
The hotline is law enforcement?
The hotline, well, assuming we're talking about the correct phone number, the hotline to the Department of Family and Protective Services would be to an appropriate law enforcement authority. It is rather the report to a supervisor that would be the activity that would not be protected under the Whistleblower Act.
If you report it to your, assuming the supervisor is not involved,
Mm-hmm.
They tell you to report it to your supervisor, then they're home free.
If they're instructed to report to the supervisor, well, I think the important point is that employees at state-supported living centers are directed and are required. They are mandatory reporters, so they are required to report to law enforcement authorities, and that is a condition of employment, so they can be terminated for that failure. It is not simply enough to report to a supervisor. One is entrusted with the knowledge and the expertise to know what should be directly reported, and I think there's some timing.
Where is that in the record? I'm sure I missed that. As a condition of employment, they have to report it to law enforcement?
That was not in the record, Your Honor, but I'm happy to provide some supplemental briefing on the policy that is found in their employment arrangement with the employers at El Paso State.
So your position here is that the statute in question has no waiver of sovereign immunity, the one that we're here under?
Chapter 260A, yes. Returning to the central question here, Chapter 260A provides no basis for suing the state. There is no waiver of sovereign immunity under that statute.
Do we know, are all of these facilities owned by the state?
State-supported living centers are owned and operated by the state. There are a number of private facilities, which I'll address in a moment, that Chapter 260A applies
also
to.
governs.
Okay.
What's-
So not all, in other words, even if this facility met, I know I'm using the term that's in the statute, but even if this met the definition of facility, not all facilities are owned by the state.
Not all facilities, yes, Your Honor, and the definition of a facility in Chapter 260A incorporates by reference 3 other definitions in other statutes. So Chapter 242 defines an institution, Chapter 247 defines an assisted living facility, and Chapter 248A defines a prescribed pediatric center. An institution, I should note, well, let me jump ahead. The appellee argues that the state should have expressly exempted state entities from the definition of a facility in Chapter 260A. Well, that exemption language is not in Chapter 260A, but it is in Chapter 242 and 247. This is the type of language that Navarro expressly argues shows that the legislature was not intending to waive sovereign immunity. Accordingly, Navarro has inadvertently admitted that a state-supported living center, just simply by the definitions, cannot be an institution or an assisted living facility under Chapters 242 and 247. That leaves only a prescribed pediatric center. A prescribed pediatric center provides non-residential treatment, whereas a state-supported living center provides residential treatment. And since the state entities can only exercise what authority they have that is granted to them by the legislature, there cannot be any overlap. Residential treatment is the only type of service that is provided by a state-supported living center. So accordingly, a facility cannot encompass a state-supported living center. This is the only, I should note, this is the only textual argument that the appellee raises. Only text can express legislative intent, not the absence of it, and not any other concern like a policy concern. But the type of text here, at most, would be ambiguous. In Wichita Falls State Hospital versus Taylor, and then affirmed later that, I believe, very year in Center for Healthcare Services versus Quintanilla, the Texas Supreme Court considered a very similar statute that incorporated by reference a definition of suable entities, like the statute at issue today, that included both private and public facilities. And in both of those cases, the court found that for 2 primary reasons, the ability to sue both private and public facilities, the ability to sue private facilities would render the statute not meaningless if one were to construe the statute as not allowing suit against the state. In other words, the statute could not be rendered meaningless if one found no waiver of sovereign immunity because there was still a viable right of action against private facilities. Further, under the second canon, or aid of construction, articulated in Taylor and Quintanilla, this language, incorporating by reference other statutes with lists of potentially suable entities, at best inserted ambiguity into the statute that was argued to waive sovereign immunity. Ambiguity is always resolved in favor of the state and against finding a waiver of sovereign immunity.
What do you do with the argument that there's an ambiguity because when you look at section 21.004, that has an exemption that says this chapter does not apply to a facility maintained or operated by the state or an agency of the state. Do you need something like that here?
You do not need express language that states that sovereign immunity is being retained or that this chapter does not apply to the state. In the absence of any such language, you use simply the guide, the test articulated in Taylor and Quintanilla. You use those 4 canons or aids of construction. You're in the same boat as if the statute lacks, and oftentimes it will, lack express language stating sovereign immunity is waived. In either case, under either direction, you use the same analysis. And that is because omitting language, legislative silence, cannot express an intention to waive sovereign immunity. There has to be the action, there has to be the expression in order to find a waiver. If you would look at the Code Construction Act, there is a presumption against a waiver of sovereign immunity. Because of that legal presumption, I believe it was argued in the appellee's brief that we had the burden. That presumption forecloses any notion that we had the burden as a matter of law of showing that there was a no waiver.
Could I ask about another argument that Navarro makes? The argument is that generally the legislative intent behind Chapter 260A is to protect residents of facilities from abuse, neglect, and exploitation, and this would be undermined if there's immunity here.
I'm glad you brought up that point, because as an initial matter, I should note that the ephemeral policy, the unarticulated, unstated policy behind a statute simply is not statutory text, so we can disregard it at the first step. Further, it is a mere assumption that I'll address in a second is incorrect. It is a mere assumption that residents at state-supported living centers would be left unprotected if one public employee could not file suit under this very particular statute. Not only are residents at state-supported living centers protected, well, by the by the public employees that work there, they are also protected by the Health and Human Services Commission's Adult Protective Services, which conducts investigations, and we cited to the Human Resources Code that talks about these investigations. Conducts investigations in state-owned entities to root out and ferret out any notion, any evidence of abuse and neglect. Moreover, as I've already discussed, the Whistleblower Act, to the extent that the employment status of a public employee furthers the interest of protecting residents, whether at public or private facilities, they are protected under the Whistleblower Act. The legislature has weighed competing interests and made the policy determination to prescribe a cause of action under the Whistleblower Act. It is not, as discussed, it does not encompass reports to supervisors, but it does provide a method of protection that Navarro could have taken advantage of had she reported as directed to law enforcement. I see my time is almost to an end. I'd like to conclude simply by noting that what should already be readily apparent, and that's that if the court were to affirm the trial court, it would constitute a wholesale rejection of, and reasoning, a rejection of all the reasoning and precedent of every single Texas Supreme Court opinion to have considered this issue over the last 2-3 decades. Since 2006, in Tuke versus City of Mejia, the court has consistently refused to even entertain implicit waivers of sovereign immunity. The last time the Texas Supreme Court did find a waiver of sovereign immunity on a particular statute was in Kerrville State Hospital versus Fernandez in the year 2000. In both that case, as well as City of LaPorte versus Barfield, which my friend has cited, there was explicit reference to a government entity, a city in LaPorte versus Barfield, and state entities in Fernandez. Thus, there was clear and unambiguous legislative language, statutory language, that one could ground a decision waiving sovereign immunity. There is no such phrase, no such word in Chapter 260A upon which to justify such a ruling. The legislature knows how to waive sovereign immunity. It can do so with express language. It can do so implicitly with clear and unambiguous language. There is none such in this statute. For that reason, we respectfully request the court to reverse the trial court and dismiss this case with prejudice for lack of sovereign immunity. I'll reserve the remainder of my time unless there are any further questions.
Thank you, Mr. Keeney.
Thank you.
Mr. Osterberg?
Good morning, Chief Justice Brister, Justice Field, Justice Ferris. My name is Michael Osterberg. I'm here for the plaintiff in this case, the appellee in this case, Kathy Navarro. Thank you for having us, and thank you for your time this morning. So this case is not about one public employee. It's not about one report that she made. This is about every employee that stands in the shoes of Ms. Navarro, who works in a state-supported living center, who sees abuse, who sees neglect, who sees exploitation, whose job should be protected when they make a report of abuse, neglect, and exploitation. And it's not just for Ms. Navarro or the other public employees who stand in her shoes, but it's for the victims of this abuse, for the victim of this neglect. A finding that the state of Texas has sovereign immunity in this case would devastate the protections given by the legislature to that vulnerable population. And in providing a retaliation cause of action for an employee terminated in response to her report of abuse, neglect, or exploitation, by doing so, the legislature expressed its intent to protect these voiceless populations and by protecting the employees who report the abuse.
Why doesn't the Whistleblower Act work for that here?
So the Whistleblower Act requires a report to law enforcement. In this case, Ms. Navarro reported to her supervisor. And it was the final report that Ms. Navarro made that it was essentially the next day she was terminated. But months prior, she had made a call to the hotline, and she was told in no uncertain terms by her supervisor, do not call that hotline, you come to me. And so that is what Ms. Navarro was operating under, where she saw something that she believed was abuse, neglect, or exploitation. She was working as a dental hygienist in the El Paso State-supported living center. Other hygienists were attempting to do x-rays on a 60-year-old wheelchair-bound patient with the mental capacity of a 2-year-old, and they started to restrain him in a way that she believed was violative of the policies at the living center. She asked them to stop. They didn't. She reported it to the dentist under whose supervision she was working, who wasn't in the room at the time, and the next day she was fired.
But the whistleblower statute has been under attack for at least 20 years by people saying law enforcement authority is too restrictive. And Texas Supreme Court repeatedly says law enforcement means law enforcement. You want a broader waiver than that, you're going to have to go to the legislature, and the legislature hadn't done it. This seems like kind of a backdoor way to expand the whistleblower statute against the state, and something that mostly applies not to the state, but to other facilities. And if that's what they intended, that's perfectly fine, but wouldn't we expect them to do it more clearly?
Your Honor, and there are cases that talk about this. Even in the Wichita Falls versus Taylor case, the Supreme Court there specifically said there are no magic words required to find a waiver of sovereign immunity, and the statute need not be a model of perfect clarity. I assume if the legislature was a lot better at writing statutes, a lot of us would have a lot more free time on our hands.
That's what the courts say, but what the legislature says, it has to be clear and unambiguous. And, sometimes judges don't feel comfortable with these things, and they may kind of slide around them, but, it's not what our oath we're supposed to do.
I think the courts reflect your expression there. Like, not only in the Wichita Falls case, they talk about, well, there doesn't need to be this magic language. In the Kerrville case, they state that the clear and unambiguous requirement is not an end in itself, but merely a method to guarantee that the courts adhere to legislative intent. And I think in this case, the legislative intent, to me, is very clear in the title of the chapter, Reports of Abuse, Neglect, and Exploitation. That is a statute enacted by the legislature to protect the residents. And how do we protect them? We tell the employees there's a criminal penalty if you don't report abuse, neglect. We also tell the employees you can't be fired if you report abuse and neglect. And so putting an onus in the chapter, putting an onus on the employee that you have to report instances of abuse, neglect, and exploitation But allowing the state to then fire the person for
Well,
making that
yeah.
report, just, it doesn't make sense and it's just not coherent.
I see that, but the 260A009 says Ms. Navarro would be immune from civil and criminal liability because she reported to a supervisor. If that includes her in .014. So we would have a clear waiver of criminal and civil liability against her, but not against the state. Is there other places where immunity is in here other than the, there is the cause of action. She's got a cause of action, but again, a cause of action does not waive immunity. You gotta have that separate.
Right, I agree, and I think those two things you mentioned actually work together. So if she doesn't report it, if she knows of abuse and doesn't report it, then she's can potentially be criminally charged.
Right.
But she cannot be criminally charged if she does report it. Like she can't, and I think maybe that goes to like, you know, defamation or some other thing where it's like, well, you accused me of X, Y, and Z, which is horrible, but she can't be sued for that. And the criminal immunity she has for making a report it works right together with the criminal liability she has if she doesn't make a report. So those two things aren't opposite. Those two work together.
And I'm sorry, go ahead. And you're in agreement that the word facility can refer to either state or private entities?
Absolutely, absolutely. I don't think there's anything in the definition that would preclude including state facilities in here. And as you pointed out during my friend's argument, the legislature knows how to exempt state facilities from those types of definitions, and they chose not to here.
Do you agree that, you know, the bottom line analysis on sovereign immunity is whether the statute would be rendered meaningless if we took state agencies out of it? Is that the standard? And if so, do we have that here?
I wouldn't call it the bottom line or the ultimate issue. I think it's a factor among several as Taylor points out, it's a factor among several to consider. In Taylor, they talk about you know, whether or not the statute would be pointless if they find sovereign immunity or if they don't find sovereign immunity. In that case, you know, they talked about going back into the legislative history and that statute was specifically directed at private facilities. And the legislative history indicated that the private facility and what was going on in private facilities was what the legislature had in mind. I didn't find anything similar in this instance. And like we pointed out in our brief, the state has no less an interest in ferreting out abuse, neglect, and exploitation in their own facilities than they do in private facilities. And that's what the purpose of this statute is, you know, I understand my friend saying, you know, they've got all these investigative arms and ways to find abuse and neglect, but the type of abuse, neglect, and exploitation that happens in state-supported living centers or any center, private or state, where there are vulnerable populations, maybe pediatric patients, the elderly, the infirm, 60-year-olds with the mental capacity of 2-year-olds, abuse, neglect, and exploitation of that population only comes to light through whistleblowers. It only comes to light through employees who are courageous enough to speak up. And the legislature wants to protect those employees by saying, listen, you can make the report and you won't lose your job over it. And like I said before, the idea that they can put a criminal penalty on her to say, if you don't report abuse, neglect, or exploitation, we can throw cuffs on you. But if you do, we're allowed to fire you in retaliation. It's just incoherent, and that's where we go back to the legislative intent. There's no way that the legislator intended such a result in this case. And like I said before, you know, we all know that legislators don't always write the clearest statutes, but the courts have already made room for that. The Texas Supreme Court has made room for a court like yourselves to interpret, to make interpretations that are consistent with the legislative intent, allowing for the fact that we don't need magic words. It doesn't need to be a perfectly worded statute. Really, you can use your common sense to say, look, it doesn't make sense that we could criminally penalize someone for not exposing abuse, but then fire them in retaliation for exposing the abuse. And the statute makes a lot of sense to include this cause of action. And there's really no reason not to apply it to the state. They're not excluded from any of the definitions. They are certainly an institution under this case. And like I said, it's not just about Ms. Navarro or the report she made or her job. It's about the pediatric care facilities that this applies to. It's about the assisted living homes this applies to. It's about the state-supported living centers across the state of Texas. And in my brief, I mentioned that on the Health and Human Services Commission's website, you can find the populations of these state-supported living centers in Texas. This is over 1,000 people just in the state-supported living centers, without getting into pediatric care facilities, without getting into other assisted living centers. There are over 1,000 patients in the state-supported living center system across Texas that will be affected by this. And all of the employees that work in those facilities, who are the eyes and ears for the legislature. That's why the legislature makes a cause of action like this.
Could I ask you one question about something your opposing counsel raised, just in terms of burden? So who has the burden when there's a state entity involved of demonstrating a waiver of sovereign immunity?
Your Honor, I think since it's purely a question of law, there's no facts at issue here. We're purely interpreting the statute. I think whoever the burden falls on, the question is, did the legislature intend to, we all have the.
It's a legal issue analysis.
Right, it's just a legal issue analysis, yeah. And the question is simply, did the legislature intend for the state to get a free pass to fire in retaliation employees who, in compliance with their legal duty, on pain of criminal punishment, make a report of abuse, neglect, or exploitation that they witness? That's the question here.
Any other questions? Thank you, Mr. Osterberg.
Thank you so much.
Briefly, Mr. King?
Thank you. Thank you. Just a few brief points I'd like to make. I want to clarify that as a general matter, a facility can encompass both private and state entities, but as a matter of definition in Chapter 260A, facility, as it's defined, can only refer to private entities. By incorporating Chapters 242 and 247 and 248A, all of which expressly apply only to private entities, there's just simply no basis to find that a facility under the statute applies to a state-supported living center, as I've discussed when I was up here before. That, as far as policy is concerned, defeats all of the arguments that my friend has raised regarding, she would be put in handcuffs if she reported to a supervisor, she would be threatened with civil liability if she reported to a supervisor and then was fired, simply because Chapter 260A does not impose upon her any obligation to report to supervisors. Her obligation to report to law enforcement authorities is found elsewhere.
So are you saying, just taking that to its logical conclusion, are you saying that because it doesn't apply, if she makes this allegation to a supervisor, she could actually face criminal liability or civil, like she wouldn't be exempted because the statute doesn't apply?
It wouldn't be the fact that she had made the report to her supervisor that would put her in danger of criminal liability. Criminal liability does not come into play at all because we're talking about the Whistleblower Act and her obligations under the terms and conditions of her employment and the obligations under the Whistleblower Act. 260A's criminal liability is not applicable to employees at state-supported living centers. Further, again, these are all policy arguments. As we've discussed, sovereign immunity is not always fair, and the legislature has oftentimes considered whether to expand the Whistleblower Act. I agree completely that this is simply a backdoor way of raising a policy argument and expanding the scope of liability, exposing the public treasury and state entities to additional lawsuits that they would be forced to defend and divert other resources to instead of conducting other state business. These are the concerns that in Neighborhood Centers Incorporated versus Walker, the court said were exactly within the realm of the legislature to consider. Just because a policy, public welfare, for example, as expressly stated in Walker, just because a policy might be furthered by expanding whistleblower protection does not indicate whatsoever the legislature's opinion on whether or not it wishes to allow suits against it. With that, I have, unless there are other further questions, I have nothing to add.
Thank you, Mr. Keeney.
Thank you.
Bailiff will adjourn the court.
All rise. Court of Appeals